One other bill President Buhari should sign into law as at 17 November 2022. President Muhammadu Buhari signed the Nigerian Startup Bill into law on 19th of October 2022, causing great excitement in the startup ecosystem. I heard in a piece published earlier this year stated that the Nigerian Startup Bill is an important piece of legislation for the purpose of creating a legal and institutional framework for the development of startups in Nigeria and for protecting the space from fraudulent, unlicensed, and unregistered entities. I, however, added that the projection of a holistic legislation as a panacea to regulatory uncertainties and investment attractiveness is a little bit too optimistic and impracticable considering Nigeria's multi-regulatory landscape. I posited that constant engagement with stakeholders, all other levels, until the legal and regulatory space catches up with ongoing innovation should always be required. It is therefore hoped that there should be the political will required to affect the provision of the Act in a manner that should attract the volume of venture capitalism needed for astronomical growth and Nigerian startup ecosystem is capable of. For a country with the human capital and population that Nigeria has, the tech startup ecosystem presents one of the most sustainable opportunities for the country to develop its economy and tackle the big twin problem of poverty and unemployment. There is another piece of legislation awaiting the assent of the president that is also capable of attracting investment and tourism of a different kind into Nigeria. It is hoped that Mr. President will sign this bill into law before the end of his administration. The bill in reference is the Arbitration and Mediation Bill, which has been passed by both legislative houses. The Senate passed the bill on the 10th of May 2022. The Extant Arbitration and Conciliation Act was enacted in March 1988, giving the growth and development in international trade and investment generally and internationally, commercial disputes, particularly since that time. It is unsurprising that that piece of legislation has become grossly inadequate to deal with settling of both local and international commercial disputes through attractive dispute resolution mechanism. With the growth of alternative dispute resolution and arbitration and mediation being the two most popular of the alternative modes of settling commercial disputes, Nigeria has witnessed a huge number of exports of arbitral proceedings to more friendly climes where the laws and procedures adequately ensure better outcomes for the parties. Given the party-driven nature of ADR, it has become common practice for contracts between even Nigeria contracting parties or contracts to be performed in Nigeria to specify arbitral seats or rule of procedure out of the country. It is not uncommon to find contracts to be governed under Nigerian law, choose countries such as United Kingdom, Singapore, or South Africa as seats for the arbitration. A quick example is the notorious P&ID case where the seat of arbitration was London. The current bill awaiting the assent of the president is not the first attempt to amend our arbitration law. Two bills were drafted in 2006 by the National Committee on the Reform and Harmonization of Arbitration and ADR laws in Nigeria, which was chaired by the notable Joseph Olakunle Orojo. However, those bills did not crystallize into substantive legislation. Following the amendment of the United Nations Commission on International Trade Laws Model Law on International Commercial Conciliation by the adoption of the Model Law on International Commercial Mediation as well as the adoption of the UN Convention on International Settlement Agreements resulting from mediation, the Singapore Convention in 2018, the current bill was drafted. The bill makes a number of protective provisions for arbitrators, which give more validation to the process and provide comfort for the contracting parties. First, the bill properly grants an arbitrator independence from the appointing party by providing that the authority of an arbitrator is not revoked by the death, bankruptcy, insolvency, or other change in circumstances of the party who appointed the arbitrator. An arbitrator's authority is revoked only by his or her own death. The bill also provides for the default number of arbitrators as one where parties have not agreed on the number of arbitrators. It further provides that no one is precluded from acting as an arbitrator because of his or her nationality, unless otherwise agreed by the parties. The bill grants immunity to an arbitrator, appointing authority, or arbitral institution in respect of anything done or omitted in the discharge or purported discharge of their functions unless the action or omission was done in bad faith. With respect to the appointment of arbitrators in international arbitration, the bill provides that where the parties have not agreed on any procedure for the appointment of an arbitrator or an appointing authority, the director of the Regional Center for International Commercial Arbitration, Lagos, shall be deemed to be the appointing authority designated by the parties. The bill also makes a number of essential procedural provisions. It provides for the appointment of an emergency arbitrator where urgent steps are required to protect the interest of a party, pending the final determination of the dispute. There is a time frame within which a contracting party may make such request, and any decision made by an emergency arbitrator is binding and enforceable. A very ingenious provision made in this regard is the choice of a contracting party to either approach the regular court for such interim measures or to seek the appointment of an intervention of an emergency arbitrator. The bill also expressly recognizes the validity of virtual proceedings by video teleconferencing or other technological aided means. The innovative provision in the bill include the consolidation and joinder of parties. The bill provides that parties may agree that the arbitral proceedings should be consolidated with other arbitral proceedings, including arbitral proceedings involving a different party or parties with the agreement of that party or parties. The arbitral tribunal is also empowered to allow an additional party to be joined to the arbitration, provided that the additional party is bound by the arbitration agreement that led to the proceedings. These provisions would enhance procedural efficiency by reducing the time and cost of multiple or parallel proceedings and reduce the risk of inconsistent awards. On awards, the bill provides for the limitation period of enforcement of awards to exclude the period when the arbitration or mediation proceedings are ongoing. The bill also limits the grounds on which an arbitral award can be challenged. It expressly states that an error of law on the face of an award will not constitute a ground to set aside an award. The bill is also silent on misconduct being a ground for the setting aside of an award, thereby narrowing the grounds upon which an award may be validly challenged. The bill creates an award review tribunal to whom an application to challenge the award may be made. One of the most exciting provisions in the bill relates to third-party funding. The bill abolishes the thought of maintenance and champerty and makes substantive provisions for third-party funding in arbitration seated in Nigeria and arbitration-related proceedings in any Nigerian court. Third-party funding as a concept in international arbitration is accepted in many jurisdictions. However, only Singapore and Hong Kong have expressed legislation adopting it. Third-party funding is a non-recourse arrangement whereby a party to an arbitration proceedings is funded by an independent fund with no prior connection to the dispute, with a view of sharing in any potential damages that may be awarded. This was disapproved of in many jurisdictions under the thought of maintenance, the improper support of litigation in which the supporter has no legitimate connection. And champati occurs when the maintaining party pays some or all of the cost of a party in return for a share of the proceeds of the action or suit. By abolishing both thoughts, the bill makes room for third-party funding. The bill further specifically provides that an arbitral tribunal must fix the cost of arbitration in the award, and such costs include the cost of third-party funding. It is believed that permitting third-party funding is advantageous to a jurisdiction attractiveness as an arbitral seat in view of the substantial growth in funding activity in arbitration over the years, with the global funding industry now said to be worth in excess of 15 billion US dollars. Another exciting provision of the bill is the codification of the practice of mediation in Nigeria. The bill recognizes and defines mediation as the process whereby parties request a third person or persons to assist them in their attempt to reach an amicable settlement of their dispute arising out of or relating to a contractual or other legal relationship, whether referred to by the expression mediation, conciliation, or an expression of similar import. The codification of mediation, conciliation, or similar modes of alternative dispute resolution provides an integrated procedure channel for enforcing other alternative dispute resolution clauses in an agreement. The bill, if signed into law, will significantly remodel the administration of arbitral proceedings under Nigerian law and provide for a more efficient and innovative means of administering and enforcing arbitration and mediation agreements and proceedings. This would in turn make Nigeria a more attractive choice as a seat of arbitration by contracting parties. It is hoped that the progress the bill has made will not be wasted and that the president will assent to the bill before the end of his office. Now, wow, this document is by lawyers, all right, seeking the president to sign arbitration bill into law for handling arbitration-related cases, settling transaction dispute, and all of that, both local and international. He has cited that only Hong Kong and Singapore is where they have such a framework functional and have the courts where such cases are handled. But he is saying here that for arbitration cases to be handled in Nigeria, this bill has to be signed into law for handling both local and international transaction dispute and settling of and reconciliation of transaction dispute or trade disputes. All right. So I'm sure these lawyers are the people making this excerpt and also trying to encourage Buhari to sign that arbitration bill into law before he leaves office, so that Nigeria will become one of the countries that has a functional legal framework and seat for handling trade disputes, both local and international. So this is a nice one because what it's saying here is that in the past, most trade disputes, especially international trade disputes involving Nigeria or Nigerian parties, have actually been referred to either Hong Kong or Singapore or South Africa for handling. Nigeria has never been a place to handle such international trade disputes because the legal framework has not been in place. So this arbitration bill that they are urging Buhari to sign into law will make that happen, and most international trade disputes will rather be settled in Nigeria rather than exporting such cases to somewhere else to handle and discuss. This is a good development, but again, if they handle international trade disputes in Nigeria with their level of corruption, even within the judicial system, I wish we'll have honest judgment in our Nigerian courts handling international trade disputes or arbitration cases here in Nigeria. Because here is where money and bribery and corruption can influence judgment. So if you ask me, I would say such cases should still be going to countries where justice will be meted out without any influence or inducement. Because any case that is handled in Nigeria always face inducement. All right? People, even the judiciary system is already corrupt because of huge, humongous amount of money they get from politicians to utter different kinds of cases. What if the arbitration case or trade dispute is involving a Nigerian politician with another foreign country, or a Nigerian company owned by a Nigerian politician is being involved by an individual who is also a foreigner from another country, and you want the case to be handled in Nigeria because the trade would have been transacted in Nigeria, and probably the defaulters are also in Nigeria. At the end of the day, bribery and corruption will say the truth. We speak, and then the case will remain there for years, because Nigerian cases are always in the court for decades. They don't finish case on time, and that is why they have a lot of people in detention without trial. So this has to be properly read before Buhari signs. He shouldn't just sign it, because I don't think we are really mature to handle this kind of complex arbitration cases in Nigeria, especially when it involves international transactions. So thank you for listening, and also let's have your comment and your view on this bill that they want to be signed into law below. That's for sharing as well.